started.
Good morning, colleagues, ladies and gentlemen, and allow me to welcome you to this very first in a series of the many webinars that AFSA will be hosting in days and months to come. More than 200 people have registered for this webinar, and as I said, I welcome each and every one of you. If I may introduce myself, my name is Lindy Nkosi Thomas, the Vice Chairperson of AFSA. I am a practicing senior counsel under the auspices of the Johannesburg Society of Advocates. I will be acting tonight as the moderator of this esteemed and distinguished panel. The webinars that AFSA will be hosting in the days and months and weeks to come will explore international arbitration, the themes that pertain to international arbitration topics, as well as intricacies of the new AFSA rules on international arbitration. These rules, colleagues, ladies and gentlemen, came into force on 1 June 2021. Among the things that these rules have sought to do was the establishment of the AFSA International Court, which will guide policy, monitor the work of the Secretariat, and also speak for the African interest in international arbitration. It is my singular honor and privilege to introduce our speakers this evening. Firstly, colleagues, ladies and gentlemen, allow me to introduce the retired Chief Justice of the Republic of South Africa, Honorable Justice Sandile Ngcobo. He is the inaugural president of the AFSA International Court. He's one of South Africa's most eminent jurists. As Chief Justice of the Republic of South Africa, he presided over the Constitutional Court, that being the apex court, and he has served this country with great distinction. Following his retirement from active service as a member of the judiciary, Justice Ngcobo has become a leading commercial arbitrator. He is admirably suited to shape the policy and direction of the AFSA International Court in accordance with the highest values of our constitutional dispensation. He will speak tonight on the constitutional, legislative, and judicial support enjoyed by international arbitration in South Africa. In creating its rules and in setting up its court, the AFSA International has enjoyed the support, guidance, and involvement of leading international practitioners throughout the world. Therefore, tonight, we are joined by a colleague from the London Bar, a London Queen's Counsel, Edwin Glasgow QC, a hugely experienced international arbitrator. Edwin is one of the prominent international figures who has devoted time and attention to the work of AFSA and AFSA International in particular. We are delighted that tonight he will speak in his capacity as the Vice President of AFSA International Court. He will help ensure that AFSA's practices and administration accord with the demanding and exacting criterion of international arbitral institutions. He will speak on the proper role of the AFSA International Court, namely to assist, whether to assist or interfere, in other words, to get the balance right. Ladies and gentlemen, we shall hear from Edwin when the time comes. Thirdly, allow me to introduce my good friend. We call each other my lady, Miss Julia Leroux, who is the secretariat, who has the secretariat of AFSA International. And in that capacity, she's always available to assist the parties and their legal counsel through the process. Julia has the singular distinction of being an attorney fully qualified to practice both in mainland China as well as in South Africa. She is currently pursuing a postgraduate degree in arbitration and has carried the responsibility of administering AFSA's significant international caseload since 2017. Excuse me. Julia will speak on the interaction between the disputants, counsel, attorneys with the registry of AFSA International. Fourthly, ladies and gentlemen, allow me to introduce a colleague, Pat Lane, who is well known domestically and globally for his international arbitration distinction and expertise. He is the chair of AFSA International Division, and his dynamic leadership, supported by a management committee drawn from the AFSA founding members, has created AFSA International and established it as the leading African arbitral institution. Pat will speak on AFSA International, a view to the future. Now, last but by no means least, allow me to introduce you to Michael Cooper, SC. Michael is the founding chairman of AFSA, who has led the establishment of AFSA more than 20 years ago and has led AFSA from strength to strength ever since. Under his leadership, AFSA now has divisionalized and has no less than 5 divisions, one of which is AFSA International, headed and led by Pat Lane. Under Michael's leadership, furthermore, AFSA has been nominated through the SOAS of the University of London as the leading arbitral institution on the African continent. And that, if I'm not mistaken, happened last year after a survey was conducted by the SOAS. Michael will be our first speaker. He will set the scene and in its broader context, dealing with AFSA's national portfolio and activities and projects, AFSA's regional activities and projects, and indeed international projects under the auspices of AFSA. Just a few words, please, ladies and gentlemen, as regards protocol. Please ensure that you are muted at all times. And following the presentations by the various speakers, we shall make time and space for a Q&A, question and answer session. Please, ladies and gentlemen, let us bear in mind that we are in difficult times. And by that, I mean, shall we be mindful of the curfew and let us stick to the time allocated to us so as to conclude this session by no later than 7:30 tonight. So just in the way of the order of the speakers, Michael Cooper will speak first, Pat Lane will be the second speaker, Judge Ngobo will be our third speaker, and Edwin Glasgow will be the fourth, and Julia, our registrar, will speak last, at which time we shall take questions from the floor. Michael, if you are ready, please, floor is yours.
Thank you, Lindy, and good evening, everyone, and welcome. As we all know, arbitration operates in that private space which the law reserves for it. And the law can prescribe, and it does prescribe, how the courts will interact with the informal dispute resolution mechanism. And the law can and does set the standards which those mechanisms must meet. But neither government, nor parliament, nor the law can provide the infrastructure which is necessary to convert that private space from an empty space, from a void, into a properly developed and credible system for resolving disputes. AFSA was launched by Dr. Dalla Omar, first Minister of Justice in this constitutional dispensation 25 years ago. At that time, there was no system of administered arbitration in South Africa. Disputes were resolved ad hoc, and they left no trace. There was no innovation, no benefit to the business community at large. The space reserved for arbitration was largely an empty space, a void. And this was the very point that Dr. Dalla Omar made. We need to find the purpose for which AFSA was created. AFSA, he said, and I quote, "will fill this void, and I wish it every success. We should devote our collective energy to ensure that the AFSA project is a success and becomes a component of a larger vision." That larger vision to which he referred was a vision of a fully developed arbitral system, serving the business and investment community domestically, regionally, and internationally. Ladies and gentlemen, tonight we unveil a new infrastructure which fully complies with demanding international standards and which recognizes a new reality, namely that South Africa has been transformed into the leading international arbitration center in Africa, and that it fully justifies the assessment by the School of Oriental and African Studies to which Lindy referred, which ranked it the top arbitral center in Africa. You may question whether there is any real need for this elaborate infrastructure, which has involved the crafting of rules by an international task force and the appointment of a court, which includes such an array of eminent figures. The answer is yes. The notion that South Africa can and will emerge as the leading arbitration center in Africa is not an illusion. Parliament enacted the International Arbitration Act 3.5 years ago. It thereby reserved the space for international arbitration and provided the basis upon which that space could be monitored and utilized. Since that time, the AFSA International Division, with Julia as its registrar, has dedicated itself to the creation of the necessary infrastructure which could convert a piece of legislation into a viable arbitral seat. In those 3.5 years, close to 100 international matters have been registered with AFSA, and they involve counterparties from across the world. It is instructive to note that by 2019, more international disputes arising in sub-Saharan Africa were referred to AFSA than to the ICC, or to the LCIA. AFSA, of course, has never limited its vision or its duties to South Africa alone. It is, after all, the arbitration foundation of Southern Africa. AFSA has committed itself to the SADC law societies to standardize and to harmonize arbitration in the 16 countries which constitute the South African development community. The rules of AFSA International, the experts of its court, the services of its administration will all be available throughout SADC, and a panel of SADC arbitrators nominated by the law societies of each country is already in place. Whilst building the infrastructure, AFSA has been active, very active, in establishing international relationships of strategic importance. 5 years ago, the 51 states who are the members of the Forum of China-Africa Cooperation resolved that an arbitration mechanism should be designed in support of China-Africa trade and investment. AFSA was fundamentally involved in crafting that initiative. What it envisaged and what has come about is that leading arbitral institutions in China and in Africa would band together to offer a joint platform with shared rules and with shared panels for the resolution of such disputes. That platform, the China-Africa Joint Arbitration Center, is now a partnership bringing together 6 arbitral institutions located in Shanghai, Beijing, Shenzhen, in the OHADA countries of West Africa, in Nairobi and in Johannesburg. We have created an intercontinental framework in support of China-Africa trade and investment. And during the course of this year, the partner institutions finalized the rules, adopted a constitution, and set about creating the shared panel. It has been a long and difficult journey, but of fundamental importance to ourselves, to South Africa, and to building a bridge between the continent of Africa and China. AFSA has established independent relationships with leading arbitration entities in China. It has been invited to participate, and it has participated in the design and the planning of the dispute resolution element in the Belt and Road Initiative. Lindy Nkosi Thomas, our moderator this evening, heads the AFSA team, which is working with the legal communities of the BRICS countries to replicate the KJAC structure for the BRICS countries, again opening up a network of global importance in the world of arbitration and dispute resolution. AFSA has also forged close working relationships with the leading international arbitration firms of Europe and the United Kingdom, many of whom are now listed as AFSA founding members, and whose contribution and whose guidance has been invaluable. The pandemic has, of course, handicapped AFSA's ability to pursue its many interests as actively as it would have liked to do. Nonetheless, as the introduction of the international rules and the establishment of the International Court shows, we remain actively building for the future. Thank you very much.
Thank you. Thank you very much, Michael. Patrick Lane, may I hand over to you? Patrick, I think you're muted. Would you be so kind as to unmute yourself, please? Thank you.
There we go. Am I? Well, now
Yeah.
people can hear me.
Yeah.
Good.
Thank you.
Good evening, all. Well, one of the difficult webinars, of course, is we look at ourselves and we don't see anybody looking at us. But I want to pick up on a few issues which were raised by Michael and by Lindy, because as my topic says, we are looking at a vision to the future. That vision started with an international act which took 24 years to come into being, to govern international arbitrations, a recognition that we needed to provide the mechanism, the source, the platform for international arbitration of trade in Africa and coming into Africa. So soon afterwards, we established what was then the committee for the drafting of these rules under the leadership of Professor Maxi Scherer. Professor Maxi Scherer is a well-recognized international arbitrator herself, sits on many international associations, and we were guided by people, experts in London, in France, in Hong Kong, in Australia, and in many parts of the world, in terms of studying the best practice in arbitration as it was then practiced internationally, but not forgetting that we are African, that our soul is African, and we have a constitution which is unique to Africa, and that we had to abide the constitutional constraints of practicing international arbitration in Africa. We were guided, and I know we will hear from Justice Nkobo, by the fundamental support that the Constitutional Court has offered to arbitration and the recognition of arbitration and international arbitration in terms of our Constitution. We also had to have regard to the fact that arbitration, if we are to be recognized and used as the preferred body in Africa, is a dynamic process. And in that dynamic process, we had to resolve to keep abreast with international best practice, and also to look at international best practice and say, can we better it? By doing that, of course, we have to introduce matters which are novel and unknown to the domestic market by most arbitrators practicing domestically. For instance, we had to look at the question of the elements of joinder, expedited arbitration, of emergency arbitration, third-party funding. Those are just a few of the elements which one was looking at in terms of the approach to international arbitration in South Africa. And Lindy has mentioned that we will be holding webinars, and those webinars will be directed specifically to various elements such as third-party funding, joinder, emergency arbitrations, so that we bring to you the flexibility and dynamic process which we have designed in looking forward in terms of the International Act and the International Committee. We are also designed, and I know Edward would also touch upon this, is that we are here to provide an affordable process. Now, we know, and one doesn't malign international organizations, but one knows that in terms of the African economies and the process of transformation and the necessary processes that have gone with it, that the economies of the African countries and emerging markets have suffered. And consequently, we need to produce a process which in Africa is affordable and recognizable by the international world. Another element which is very, very significant and important in this process in looking at the vision going forward, and that is the understanding of the position of neutral arbitrators and saying the position of our arbitrators, acquainting them with the best standards in international arbitration. We all have a learning curve to go through. We have the ability, we have the scope, and we have the arbitrators. It introduces international arbitrators into our fold. We have established an international panel of arbitrators, and we can draw neutral arbitrators from numerous countries international, from London, England, from France, from Italy, from Hong Kong, from Australia, and of course from Africa. But in order to appreciate and fully understand and utilize what the benefits are of the new international rules, it also requires that the users of those rules understand how those dynamic provisions work for them and in particular cases, their clients and representatives. Michael also touched upon the question of establishing a platform. Now, that platform has many facets to it. The platform, which Michael described as filling that void, has practical elements to it as well. And that is, AFSA provides facilities which are comparable, if not better, than many worldwide facilities for the administration of arbitration. It is able to administer an efficient process. And it has a panel, as I said, of skilled arbitrators in both adjudication and the arbitration of international disputes. I don't want you to take too much more of your time, and because the webinars will interrogate and investigate those elements of the rules which are dynamic and perhaps novel in the domestic market. And I really wish now to hand over to others who I think will contribute hugely to the understanding of the vision that we are creating. Thank you. Thank you for listening. Thank you, Lindy.
Thank you, Pat. Thank you very much indeed. Justice Noble, may I hand the floor over to you?
Yes.
Thank you.
Thank you, Lindy, and good evening to everyone. I think the Arbitration Foundation of South Africa should be commended for taking the initiative to provide the necessary infrastructure as well as the practical support for international commercial arbitration in South Africa under the new commercial arbitration regime. Indeed, AFSA should be commended for developing and publishing international rules which came into effect on the 1st of June this year. I've been asked to reflect on the legislative and judicial support for international arbitration in South Africa. Seems to me that the appropriate starting point in a constitutional democracy like ours, which is founded on the supremacy of the Constitution, is perhaps to provide the constitutional context for international arbitration. The Constitution enters the international arbitration scene primarily through the Bill of Rights, in particular, through the requirements of public policy and the principle of fairness. What constitutes public policy must be determined in the light of the values that underpin our constitutional order. The Bill of Rights is the embodiment of these values, which include the core value of fairness in the conduct of arbitral proceedings. In determining whether the enforcement of an international arbitration agreement or the recognition and the enforcement of an award is contrary to public policy, the Bill of Rights will be a relevant consideration. The Constitutional Court has laid down the following principles concerning the applicability of the Constitution to private arbitration. Firstly, Section 34 of the Constitution, which guarantees to everyone the right of access to courts, does not apply directly to private arbitrations, primarily because they do not require public hearings. Of course, it will be interesting to know, in the light of the requirement that arbitration proceedings pertaining to public bodies must be held in public unless there are compelling reasons to do otherwise, how this will fare in the future. Secondly, while the court did not finally determine the indirect application of Section 34, having regard to the role courts have in giving effect to arbitration agreement, Section 34 may have some relevance to the interpretation of legislation or the development of the common law. Thirdly, arbitration agreements that contain provisions that are contrary to public policy in the light of the values of the Constitution will be null and void to that extent. And in determining whether a provision is contra bonis mores, the spirits and the objects of the Bill of Rights will be of importance. In the fourth place, arbitration agreements should be interpreted, unless its terms expressly suggest otherwise, on the basis that the parties intended the arbitration proceedings to be conducted fairly. Lastly, courts should be careful not to undermine the achievement of the goals of private arbitration by enlarging their powers of scrutiny imprudently. The Constitution requires a court to construe grounds for setting aside an award reasonably strictly in relation to private arbitration. Of course, the Bill of Rights is relevant to international arbitration because of Section 39 of the Constitution, which enjoins courts to construe any legislation, including the International Arbitration Act, in a manner that promotes the spirits and the objects of the Bill of Rights. And in interpreting the Bill of Rights, courts are required to have regard to international law as well as foreign comparative law. And this really brings me to the legislative support for international arbitration. The legislative commitment to promote the use of international arbitration as a dispute resolution mechanism for international arbitration dispute cannot be gainsaid, nor can its commitment to the recognition and enforcement of foreign arbitral awards be doubted. This commitment is evident from the enactment of the International Arbitration Act, which came into effect in December 2017, which, together with the international instruments that it incorporates, provides the statutory framework for international commercial arbitration in South Africa. Indeed, one of the declared objects of the Act is to facilitate the use of arbitration as a method of resolving international commercial dispute. It gives effect to this objective by incorporating into South African law the model law on international commercial arbitration as adopted by the United Nations Commission on International Trade Law, what is called the model law. In addition, it gives effect to South Africa's international obligations under the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention, which requires South Africa to recognize and enforce foreign arbitral awards. The Act and these international instruments create a legislative environment that is not only conducive to the recognition and the enforcement of international arbitration agreement, but that is also conducive to international trade and investment. Indeed, the Act represents the bedrock of those engaged in international trade and commerce, which is a key consideration for the commercial community in choosing a seat of arbitration. The legislative support for international arbitration is evident from the scheme of the Act. That scheme commences with the recognition and the enforcement of international arbitration agreement, the protection of the arbitral process, and finally, the enforcement of the outcome of the arbitral process. This scheme recognizes international agreement by permitting the parties to refer to arbitration any international disputes which the parties have agreed to submit to arbitration under an arbitration agreement, as long as it relates to a matter that the parties are entitled to dispose of by way of an agreement. The dispute in question must, of course, be capable in law of being settled by way of arbitration, and the agreement itself must not be in conflict with public policy. It enforces arbitration agreements by empowering a court to issue an anti-suit injunction, to stay litigation proceedings, and to refer parties to arbitration if the dispute before a court is subject to a valid arbitration agreement. Perhaps a significant legislative support for arbitral process is the empowerment of arbitral tribunals to grant interim protection measures which are enforceable in court. While courts are also empowered to grant interim protection measures in relation to arbitration proceedings, their powers are limited to the circumstances specified in the law. Interim measures are necessary to protect the arbitral process. They can ensure the maintenance of the status quo pending the determination of the dispute. They can prevent action that is likely to harm or cause prejudice to the process itself. They can preserve assets out of which a subsequent arbitral award may be satisfied. And they can preserve evidence that may be relevant and material to the resolution of the dispute. The manifest purpose of conferring these powers on arbitral tribunals is to avoid the delays that might occur while a party seeks an interim order from a court. Quite apart from this, by conferring these powers on arbitral tribunals, the legislature seeks to ensure that all issues that are incidental to the dispute before a tribunal are dealt with by the arbitral tribunal, and court intervention is kept to the minimum. The one aspect that I want to touch in the context of the process is the issue of confidentiality. One of the attractions of private arbitration is privacy and confidentiality. This is particularly so if the dispute involves matters that the parties consider to be commercially sensitive. On the other hand, the constitutional requirement of transparency and openness requires that matters pertaining to public bodies be conducted in a transparent and open manner. And this is essential to accountability. This arguably requires arbitral proceedings pertaining to public bodies to be held in public. The International Arbitration Act recognizes this constitutional requirement. Section 11 of the Act seeks to strike a balance between the requirement that arbitration proceedings involving public bodies be held in public on the one hand, and maintaining confidentiality by allowing such proceedings to be held in private where there are compelling reasons to do so. The Act, of course, doesn't define what constitute compelling reasons. Protection of trade secrets will in all likelihood qualify as a compelling reason for holding arbitral proceedings in private. Guidance on what constitute compelling reasons may be sought in the provisions of the Promotion of Access to Information Act. And for example, Section 64 of that statute allows a private body to refuse the request for access to a record which contains trade secrets, financial, commercial, or technical information, the disclosure of which would cause harm to the commercial or financial interest of a third party. Similarly, the Competition Act may be a useful starting point in determining what constitute compelling reasons. This statute defines confidential information to mean trade, business, or industrial information that has a particular economic value and is not generally available to or known to others. These provisions of this statute give an indication of what the legislature considers to be protected from disclosure based on confidentiality. The final phase of legislative support is evident in the enforcement of the results of the arbitral process. An arbitral award, including a foreign award, is binding and enforceable in court. A court can only refuse to enforce an award on the very limited grounds that are prescribed in Article 36. An award may also be set aside on the same ground as those that apply to the refusal to enforce an arbitral award. Broadly speaking, these grounds relate to fairness of the process, validity of the arbitration agreement, whether the award deals with a matter that falls outside of the terms of the submission to arbitration, or if the subject matter of the dispute is not capable of settlement by arbitration under South African law, or where the award is in conflict with public policy. What is immediately apparent from this limited overview of the key provisions of the International Arbitration Act is that the legislature has laid a solid foundation for the support of international arbitration in South Africa. But the effectiveness and the efficacy of the legislative scheme require judicial support. And this brings me to the final aspect that I wanted to explore this evening, namely the appropriate role for courts in international arbitration. The legislative scheme contemplates that courts will play a supportive role in the arbitral process. They play this role in 3 stages of interface between the courts and arbitration, namely before the commencement of arbitration, during the arbitral proceedings, and after the final award. Before the commencement of arbitration, court intervention may be necessary to enforce the arbitration agreement by compelling the parties to resolve their dispute through arbitration, where the dispute before a court is governed by a valid arbitration agreement. Court intervention at this stage may also be necessary to assist in resolving issues relating to the establishment of the tribunal and to address challenges relating to the jurisdiction of the arbitral tribunal. During the process stage, The court's role is to oversee the arbitral process and to clear any obstructions in the arbitral process, including the granting of interim protection orders. However, the powers of court to grant such interim orders are limited to the circumstances contemplated in the law. Their intervention may also be required to enforce interim measures issued by arbitral tribunals. Courts may also intervene after the arbitral award has been issued, where it may be necessary to enforce compliance with the arbitral award. Enforcement of an award can only be refused on the limited ground specified in Article 36 of the model law. Intervention may also be required at this stage to set aside an arbitral award. The grounds upon which a court may set aside the award are substantially the same as those on which a court may refuse the enforcement of the award. What is apparent, however, from the scheme of the Act is that it contemplates a limited and a focused role for courts in relation to arbitration. It contemplates a supervisory, supportive, and enforcement role for courts. The legislature contemplates that courts in arbitration will have a symbiotic relationship in resolving commercial disputes. Courts are expected to hold the parties to their bargains to arbitrate their dispute. In essence, the scheme embodies the principle of judicial non-intervention, which is the defining feature of international commercial arbitration law. This principle is evident from the provisions of Article 5 of the model law, which explicitly limits court intervention to the circumstances provided for in the law itself. Similarly, the court's power to grant interim measures is expressly limited to the circumstances that are specified in Article 17J2. Finally, the grounds upon which a court can set aside an arbitral award or refuse to enforce it are narrow and limited to the grounds that are specified in the law. International traders and investors can therefore expect that courts will exercise their limited powers under the law in a manner that is consistent with the philosophy of judicial non-intervention in arbitration. This, of course, is not to suggest that courts should abdicate their oversight role in arbitration. This simply means that court may not, in the exercise of their powers under the Act, undermine the achievement of the objectives of the Act by enlarging their powers of scrutiny imprudently. The Constitutional Court has provided judicial leadership on the proper approach to the exercise of the power to set aside an arbitral award, albeit in the context of the Arbitration Act. It has held that the approach in the New York Convention and in the model law suggests that the values of our Constitution will not necessarily be best served by interpreting Section 33(1) in a manner that enhances the power of the courts to set aside private arbitration award. Indeed, the court said, the contrary seems to be the case. The international and comparative law suggests that courts should be careful not to undermine the achievement of the goals of private arbitration by enlarging their powers of scrutiny imprudently. And it concluded the Constitution would require a court to construe these grounds reasonably strictly in relation to private arbitration. Based on this approach, the international trade and commerce community can expect our court to adopt a similar approach to the grounds for setting aside an arbitral award under the model law. As my colleagues who have spoken before have indicated, international commercial arbitration in South Africa is still in its embryonic stage. And there's a great deal of work that courts still need to do in developing this area of law. Courts must provide guidance to the broader international and domestic commercial community concerning the incidence of their actual and proposed contractual relationship. Arbitrators cannot offer this perspective because arbitrations are conducted confidentially and arbitral awards are not binding on other arbitrators. As our courts grapple with the issues involved in international arbitration, there are considerations that must inform their approach to this task. The first is that courts must be guided by the legislative commitment to facilitate the use of arbitration as a method of resolving international commercial dispute. Secondly, they must effectively play their oversight role, but must do so with due regard to the limitations placed on their powers by the law. Finally, courts must promote uniformity and certainty in the application of the model law. They can promote uniformity by having regard to international law and comparative foreign law as required by Section 39 of the Constitution. They can promote certainty by providing authoritative guidance on the proper construction of frequently used documents in international trade and commerce, and resolving issues concerning the nature and the scope of international convention. To conclude, International Arbitration Act and model law have laid a solid foundation for the support of international commercial arbitration in South Africa. The challenge for our courts is to build on this foundation and develop a coherent system of international commercial arbitration jurisprudence that is truly international and which will provide certainty to international traders and investors. They must create a commercial scene in which arbitrators can apply settled legal principles. Thank you.
Thank you, Justice Ngobo. Ladies and gentlemen, that is the inaugural president of the AFSA International Court and the retired Chief Justice of the Republic of South Africa. Thank you very much indeed, Justice Ngobo. May I now invite the Vice President, equally inaugural Vice President of the AFSA International Court, a colleague from the London Bar, Edwin Glasgow QC. The floor is yours. Thank you.
Thank you very much. Good evening, ladies and gentlemen. It's intimidating even to know what sort of a distinguished audience we have. And in some ways, it's a relief that you're not all facing us, I confess, but facing a screen is even more difficult. I am obviously acutely conscious of the honor it is for a very ordinary English lawyer to be invited to play even a small role in the rebirth of AFSA on the international stage, a step which is hugely important to the commercial community of Southern Africa and equally to those who do business in that jurisdiction, in those jurisdictions and in that role. It's also a huge and an intimidating honor for me to be allowed to join a panel of this distinction, and the idea that I could have anything useful to add to a leading judgment from Justice Ngobo is slightly laughable, but I'll do my best. He's stolen all my lines. It's not necessary for me really to add anything, but I'm asked to, so I'll add a little. What I do have to add is, if I may say so, seen from the other end of the telescope, it is hugely important that we have the support of the judiciary within the jurisdiction where we are seated, it is equally important that AFSA court behaves properly and delivers the service that those who use us are entitled to expect. No arbitral institution can function effectively unless it has the informed understanding and support of the legal system of the jurisdiction in which it is seated. We all have painful experience of jurisdictions where the judiciary see arbitration as being trespassing or in some way trying to compete with the local judiciary. That is not the way in which South Africa sees us, and that is itself of fundamental importance. What we on AFSA court want to do is to have everybody, the parties, the arbitrators, the witnesses, the experts, to have real confidence in the efficiency and the integrity of the whole package of the service which AFSA is providing. What I think is unique about the way in which AFSA is already running is that it recognizes that we are here to provide an efficient service in a way which everybody is entitled to expect. That means that we are equipped to cater and respect for the cultural needs and expectations of all who come to work with us. Few things can be less welcoming and less welcome than to come from a jurisdiction where the culture is wholly alien to the seat in which the arbitration is sitting, and to find oneself unwelcome, intimidated, misunderstood, and patronized. We do set high standards. You've only got to glance at the quality of those who have been invited to serve in various capacities for AFSA. I'm not sure how the slip occurred that they included me, but I'm grateful. As far as is reasonably possible, we want to ensure the court, we want to ensure the awards which we will be issuing will be enforceable and fully compliant with the New York Convention. But in doing that, we want to respect party autonomy genuinely. We want to respect the party's choice of the arbitrators who they want to use. That means that we have to be there to assist them when we're requested to do so and when it is appropriate. We will, as Pat has rightly mentioned, expect people who voluntarily agreed to arbitrate their disputes in accordance with our principles. We will expect them to stick to agreed timetables and to work within cost limits. But we will not interfere with the drafting of awards or any of the preliminary and interlocutory steps that are taken, so as to regiment people into some kind of house style or format that we think right to impose upon other people. We recognize, and this is all part of our desire and why we are so international in our structure and makeup, we want to show a real respect and welcome to the culture of those jurisdictions which are not necessarily ones with which everybody in South Africa and Southern Africa are familiar. That we think is of key importance, and getting that balance right between ensuring to the best of our ability that awards are enforceable and that the process is compliant with the principles that we want to establish. We will stop short of negative interference which obstructs the speed and the efficiency, and let it be said, the friendliness and the civilized way in which arbitration is always conducted in Southern Africa. That's what I want to contribute to, and that's the promise that I give you all. The court that is presided over by Justice Nkobo, assisted by me, will behave in that way. We believe for the common good, and that's what we are determined to do. That's all I need to say. The rest of the important bits have been said by the learned judge, and it's an honor to follow him. It's an honor to serve under him, and a great honor to be assisting in this project in a country which, as some of you know, I love very dearly. Thank you. That's all from me.
Thank you. Thank you very much indeed, Edwin. That's our Vice President of the AFSA Court. Now, ladies and gentlemen, allow me to hand the floor over to Ms. Julia Leroux, the head of the International Arbitration Registry within AFSA. Over to you, Madam Julia.
Thank you, Lindy. Thank you, everyone. I have very little to say because everyone else has introduced the background, the context, the platform, the mechanism. That's all very well. I am here for the practical part. So the AFSA Secretariat provides the administrative service, and we are here to help you and to facilitate the arbitration process, to make you feel it is not something intimidating if you haven't been working with AFSA. If you have been working with me previously, and some of the audience probably have already worked with me previously, we worked on the previous set of international rules. We now have a new set of rules. The procedure will be different from the previous rules. It is a learning curve for me as well, for everyone else. But all I want to say is we are here to help you, to facilitate you. If I don't know some of the answers to some of your questions, I have a court that I can turn to. This court consists of 16 very experienced international arbitrators. They very experienced with other international arbitration institutions as well. So I have a very good support system that I can answer your questions. And we have a few stages where we can be of help. Sometimes the attorneys would call to inquire about the model clause that they can put into the contract. They ask me questions about how this international arbitration should benefit their transaction. You can also approach me when the dispute arises, if you've already got an AFSA clause in your contract, or you can always ask me any question during the process of your arbitration. So AFSA has an online filing system that you can access from our website, where especially during this this COVID pandemic, and everyone is working from home, that just make things much easier. You can just file it online. We can deal with that. So all in all we want to say is we are here to try to help you. And administrative service purpose is to try to help you. Any of your administrative needs or any question you have about the process, about the rule, just pop me an email or call us. If I can't help you, if I can't answer, I can always ask one of our court members to answer and help you. Thank you very much. That's all I have to say. Thank you.
Thank you, Julia. Now, ladies and gentlemen, you will recall that we promised to make time, to allocate time for questions and answers at the end of the presentations of our very distinguished members of the panel. May I invite the attendees to put questions to members of the panel. For now, I only have one comment, as it were, in the Q&A box, and there, anonymous attendee is not necessarily putting a question. It would appear his comment is that these rules are really remarkable, forward thinking and a breath of fresh air in this market. But having worked abroad and now practicing back home, my lived experience is that this market suffers from enormous high court goggles. Well, perhaps this is something that Judge Ngobo would wish to comment on. Enormous High Court goggles. Looks like the suggestion is that the courts aren't quite, in some jurisdictions, as supportive as we would like them to be. That the philosophy that the judge spoke to, the philosophy of judicial non-intervention, it would seem that the attendee is suggesting that some jurisdictions don't seem to adhere to that. Then the comment continues, arbitration in South Africa is more often than not litigation in a boardroom. There is something that we need to talk about. Litigation in a boardroom, is that the case really? And litigation in a boardroom, I will ask Pat to deal with that aspect. And this, to me, is the real barrier to the implementation. So there are two real issues that arise here. The one for Judge Ngobo is the other jurisdiction not adhering to the philosophy of judicial non-intervention. Do you perhaps have a comment to levy on that? And with Pat, I have already suggested the question. Over to you, Judge.
Thank you. It's a difficult question because, you know, one is not in the minds of the judges who deal with these matters, you know, and it is true, there are some judges who perhaps seem to adopt an attitude that when matters come to them by way of review or the way setting aside an award, it's just an ordinary appeal and that there has to be a rehearing. There doesn't seem to be an emphasis on the role of arbitration and the need to implement the choice of the parties to go to arbitration. I would have thought that the decision of the Constitutional Court in Lesotho Mpapoli has laid a solid basis for what I consider to be the proper approach to the adjudication of matters involving the arbitration. You know. And the success of arbitration really lies in the hands, firstly, of the practitioners and the judges who hear challenges to arbitral award. One of the ironies of arbitration, as the two cases that I've looked at in the Constitutional Court, is that the first case, the Sophie case, for example, commenced in the High Court, and then it went to arbitration. And then from arbitration, it went to the High Court, from the High Court to the Supreme Court of Appeal. From the Supreme Court of Appeal, it went to the Constitutional Court. That entire period took about 4 years and 7 months. And that undermines the very purpose of choosing an arbitration as a fast and cost-effective method of resolving a dispute. One hopes, though, that over time, courts will begin to realize the limited role that the statute plays on them in dealing with matters involving arbitration. Thank you.
Thank you. Michael, do you wish to add something? I saw your hand going up. No?
Thank you, Lindy. Yes, I'd just like to supplement what the judge has said. In our domestic administration, my experience is that between 1 and 2 out of 10 matters will go to review or will be involved in some sort of court proceeding. And we've monitored those proceedings very carefully in the Gauteng division. And Gauteng has established a form of commercial court which is intended to expedite matters and to deal with matters which have a significant commercial element. The court is now going to recognize all arbitration matters as falling within the commercial court jurisdiction, and arrangements have been made to address these disputes as quickly and as efficiently as possible. So we have every reason to expect that the standard of interface between the arbitration and the judicial sides of the fence will, at least in Gauteng, work on an efficient basis. I may also say that whilst naturally you will always have judicial decisions which occasion some surprise, the overwhelming majority of the decisions that we have seen in the AFSA world in respect of challenges to the court have followed the pattern that one would have wanted to see and that one would have expected, so that the questioner may have come across a particularly bad example of court interface. But I do not believe, certainly in the Gauteng division, that that is the general experience. On the contrary. Thank you.
Thank you, Michael. Just to refresh your memory, Pat, the question really is, can it be said really that arbitration in South Africa amounts to litigation in a boardroom? It goes to the expeditious dispatch of arbitration proceedings. Thank you.
I think it's a common complaint that arbitration as practice sometimes leads to private litigation. But let's place it really where it ought to be. The purpose of the International Act is to create the tools. So what's happened is you have the Act, which now fundamentally supports the rules, which then provides the flexibility for skilled arbitrators. Now I use that word carefully. What we need are skilled arbitrators, skilled in the process of arbitration, not caught contextually in litigation and the ideas of litigation and its practices. The rules provide that flexibility. The fear that some arbitrators might have of stepping outside the lines of standard litigation procedures should be allayed by the fact that the rules give them that flexibility, and the courts, and going right through to Lafuna's decision, total decision in the Constitutional Court and the Supreme Court of Appeal, have supported that process, giving the arbitrators license to, in fact, identify the dispute and use the rules as efficiently and expeditiously as possible to resolve them with mechanisms which ensure fairness and due process. There is no excuse for arbitrators to adopt purely a litigation approach in arbitration. And part of the webinar process, part of the educational process, will be educating arbitrators, domestic arbitrators, and we will have international participation in the skills which are available in arbitration and the distinctions in arbitration which make it possible to introduce flexibility and expeditious and efficient resolution of those disputes. So arbitration should not be in a boardroom. And that, I think, as Edwin has already echoed, the view of the court in monitoring and promoting the efficiency of the process. Thank you.
Thank you. Thanks a lot, Pat. And this is a comment that I'm going to read out, and I'm going to ask Edwin to please comment on this. And Mohammed Hussein writes as follows: arbitration bodies need to consider reporting awards. It's about reporting awards, like the ICC does report awards, sometimes in a redacted form, so as to add to the body of jurisprudence created by the courts. Of course, the consent of the parties would have to be a prerequisite. Appropriate reductions can ensure anonymity and so on. Perhaps AFSA could book or could look into this together with LexisNexis and SAFLI. I'm not sure whether, Edwin, you are aware of SAFLI and LexisNexis, but this are just publishers, companies that publish reported cases and so on. So is this the sort of thing that we should expect from the International Court, of which you are a member, Edwin?
Thank you, Lindy. Yes, I think it is. And thank you to Mohammed for his wise question. I believe that the default position for us should be the same as it is currently for the ICC, that unless there is justification to the contrary, we should seek the consent of the parties, which will always be necessary to publish awards, even in an expurgated or an anonymized version. Having said that, however, it is essential that we are recognized, unlike some arbitral bodies, as being responsive to those who use us. If that is the wish of people, and if that is what is expected of it, that will become known. We're not going to impose our way of thinking on other people. It's not the way we're going to work. I think we will, and this is really very much more a matter for Michael, and I would invite his comment on it. But, and I know him well enough to know that if he disagrees with me, he will say so. But my own personal view is that I think we should try to adopt the default position that we would like to build up a body of jurisprudence, because I think it is of use not only to other people who may have similar cases, it is of use to other arbitrators. It may even be useful to some members of the judiciary to see the way in which AFSA has approached things and done them. I think the more openness we can have, the better. But I repeat, subject to Michael's view, I believe that this should be consumer-led. We want to be a user-friendly body, and we do not want people to feel that they are intimidated by some regulatory structure that goes beyond what is necessary to regulate enforceable awards. But if you would forgive me, Lindy, I would invite Michael to comment on that, because I think given his huge experience, it's something within his field and something that he would express a useful view on. Thank you.
Yes, thank you, Edwin. I endorse exactly what you've said. Can I say to Mohammed Hussein that, yes, we have embarked on exactly this project. Yes, we have spoken to LexisNexis, and we are committed, if we can, to commence publishing awards. But the point you make is, of course, absolutely right. We have gone out to the parties in major arbitrations where the awards have been excellent and of particular value in arbitration generally. We've gone out to the parties and we've asked them for permission to publish. And generally the answer, when I say generally, almost unanimously, the answer has been no. And when we have tried to persuade the parties by assuring them that we will present the award in an anonymous fashion, the answer that we've been getting is that within the South African business and commercial community, since one is dealing with commercial disputes of substance, even if you veil the identity of the parties by calling them A or B or X, they say their competitors will have no difficulty at all in identifying who they are and what happened, and the very confidentiality which they prize will be lost. we're not giving up the struggle. I do think that the room is there to publish awards, particularly in regard to matters of practice, particularly in regard to matters of interpretation of the rule, which can't possibly impact and trespass on aspects of confidentiality, but which would be of such value to practitioners wanting to see how the rules will work in practice, that we will continue, but very much within the parameters you suggest of deferring to the will of the parties as the prime requirement.
Michael, may I just add this? I'm comforted by that reassurance, and as always, to know that you agree. I think I have two small comments. One, the consent of the parties that is invited at the earliest possible stage before they know who has won and lost is much more likely to meet with success in my experience. And I'd like Julia's view on that. I think if she writes to them in advance of anything and says, we would wish to produce. Secondly, I think that the ability of skilled arbitrators to produce an abstract is what really matters. Simply anonymizing the parties, not only in Southern Africa, but of course I accept, even in some cases in Europe, will identify the international infrastructure or the project quite easily, and the party that is lost will not want it. But skilled arbitrators can produce the only thing that anybody is interested in, which is the abstract of the statements of principle. It is those that may assist in other cases. It is those that may enable us to build a body of jurisprudence. It is those that may be genuinely useful to the judiciary who we so want to support. So that's the only gloss I'd add. But again, I'm very grateful to Mohammed for his question.
Julia, would you like to add anything to what Edwin and Michael have said on this topic?
No, I think they have said the most of it, and I agree that if we should embark on this process, we should have asked the parties as early as possible, maybe include in our first letter to the parties to ask whether they would consider. That I think will be helpful, just to bring the parties also into this consideration from the very beginning, so that they are prepared close to the end of the award. Yeah.
Mm-hmm. So can I ask a question of Mike? Some of these matters go as far as the High Court and don't go beyond the High Court. Now, in that event, would there be any objection in publishing an award that gives rise to that litigation?
Yes. Yes, I've not really considered that aspect, but of course that's right, Judge, because immediately it goes to the court. The confidentiality is largely lost, and it should be very much easier, I think, to persuade the parties to allow publication on the kind of level that Edwin was talking about. I would think if I'm understanding Edwin's approach correctly, he would say, and I would certainly agree, that even in that case, one would not ignore the wishes of the parties, and one would continue to ask them for permission. But of course, there would be much more realistic prospect of their consenting. Yes, indeed.
Michael, I would only add this, that what you say, and of course what the judge says is right, that if you choose to challenge an award and seek to have it set aside, one, by definition, you are likely to be the loser, so on your own head be it. And two, if you choose to take the arbitrator's award into the public arena and challenge according to the ordinary law, you cannot but publish what it is that you are complaining about. Most of us do have experience of having awards taken to challenge in that way. The one comfort is that having been scrupulously careful to give anonymity to the losing party, when he invites criticism upon himself, it's a great joy to see the court uphold the award, publish all the reasons, give the publicity that would have been avoided, and also, I hope, make swinging orders of costs where appropriate against the misguided lawyers who pursue these things, so that people will learn that challenging arbitration, which is healthy and right and constitutional in very rare cases where we get it wrong, but simply wanting to have a second bite of the cherry will be discouraged and penalized in costs, and you'll lose your anonymity in the process. Those are my, as usual, mild and understated views.
Well, let me say in that regard, one of the categories that we have determined we would publish as soon as we can start publication would be all court reports dealing with arbitration. But let us take your situation in which Party A has challenged the arbitrator's award on erroneous, perhaps mischievous grounds, and the court has dealt with the matter in the blunt way you were hoping. To publish that award, which simply explains why the challenge has been misdirected, is easy, straightforward, and one would not require the permission of the parties. But assuming that the court's judgment did not get into the particular merits of the dispute, but merely dealt with the illogicality of a particular kind of challenge, there would remain an area of confidentiality which had not been exposed by the court proceeding, and in respect of which one might nonetheless ask for permission.
Michael, of course, I accept that each one will have to depend upon its facts, but put at its lowest, the unsuccessful arbitral party who wants to challenge runs the risk of losing in anonymity, putting it at its lowest. And the more steps the judiciary can take sensibly to discourage unmeritorious appeals, the better.
Well, very interesting debate, questions. It remains for me to thank the members of the panel and to thank all our attendees. Time is not on our side. There are a few other questions that we will endeavor to deal with differently. It's almost 7:30, and with the pandemic and the curfew situation that we have to contend with, I'm afraid we are unable to take any more questions. Therefore, thank you to members of the panel, and thank you to all the attendees. And that brings us to the end of this first of the many webinars that we will be hosting going forward. Thank you all. Great evening. Thank you.
Thank you very much.